I call the special meeting of the City of Ashland Planning Commission to order for August 25th, 2026. I will note that our meetings are available on Zoom and RVTV. The public can find information on how to participate in Planning Commission meetings in our public notices, as well as directions on how to find the full meeting materials, applications, and staff reports. I note that we do have 6 commissioners here tonight, so we have a quorum. Staff announcements?
Thank you, Chair Werner. So the first announcements, or the announcements I have, both relate to the City Council meeting that occurred on August 18th. At that meeting, the council approved first reading of Ordinance 3307, which was the modifications to address Senate Bill 974, House Bill 4307, and House Bill 2138. The council approved first reading, but did not incorporate the Planning Commission's recommendations. You'd made 2 recommendations at your August 11th meeting. One to revise the draft ordinance 20 lot threshold for performance standard subdivision down to 12. The council motioned to make that 20 lot subdivisions. Further, the council didn't adopt the commission's approach of applying a 100-foot notice area to only clear and objective type 1 housing developments and retaining a 200-foot limit for other type 1s. The council's motion directed staff to investigate the legality of requiring any notice, but failing an opportunity to reduce notice further, that they stipulated it would be a 100-foot notice for either action. But again, we're charged to look at whether notice is required. Staff does have concern over that, and looking at ORS 197-146A, I believe, which does stipulate that it minimum floor of a 100-foot limit. On Chapter 18 Housing Code Amendments, I wanted to bring forth to this commission that on the August 18th meeting, the City Council considered a councilor submitted item for making modifications to the land use ordinance in an effort to go beyond the state mandated requirements that we just spoke about. And as they stated in their package, they noted that the compliance package, quote, addresses the state's floor, not Ashland's opportunity. And so they wanted to go further with opportunities to remove barriers to housing development in Ashland. And so the council ultimately directed Councilor Sherrill and Dale to draft ordinance amendments to reflect their packet materials. They identified 18 areas for modifications, and staff is looking to bring those back to you on September 8th for initial discussion. The council did direct that the city draft a code amendment and submit to DLCD by September 17th for these areas, with a hearing before the Planning Commission on November 10th, with council consideration on November 17th. So a very fast process to address the code requirements for pre-application conferences, findings adoption, administrative property line adjustments, bonding of required improvements for final plat release, administrative review practices, lot coverage, minimum lot size and performance standards options, additional accessory dwelling units, flag light standards, which are some of what we'll be discussing this evening, hillside slope standards, supportive single room occupancy standards, which we did just modify the land use code to incorporate, recreational vehicles as an allowed housing type on all residential properties, solar access standards, landscape buffers, conditional use permit criteria, street standards, middle housing land division, and right-of-way improvements. And lastly, terminology changes. For instance, accessory dwelling units are referred to as accessory residential units in our code. So that's just a terminology change. So staff will be bringing the drafted code amendments for the commission on November 10th, once it's received from the councilors. And in the meantime, as I noted, if we can bring back to you the packet of materials from the council's August 18th meeting, you can see what was put forth by the councilors as their reasons for the amendments, and hopefully we'll have amendments in code form that can be presented to the commission in advance of or upon submittal to the Department of Land Conservation and Development to give you ample time to review before your November 10th hearing. Yes.
So just because I want to be clear, the council is challenging whether you have to have any kind of notice of planning actions?
For the type 1 actions under the House Bill 4307, it established that a city may provide direct notice to property owners within 100 feet of a property. And so when it came before this body, we saw that as a ceiling, the height, how far you could notice. But they were questioning whether the word may would allow for no notice under that standard.
So that would leave people in the community no knowledge of planning actions that were taking place unless they were tracking everything that went through the city.
For the type 1 planning actions,
Which are
correct.
most of them now.
That is, yes.
Thank you.
So that's it for the updates I have this evening. I know it's weighty, and we'll come back to you with more detail when we have it.
Okay, thank you very much. We have an item on the consent agenda for approval of minutes for August 11th, 2026. Would somebody like to make a motion to approve that consent agenda? Or are there any questions about the particular minutes?
I'll make a motion to approve the consent agenda.
Is there a second?
Second.
It's been moved and seconded to approve the consent agenda. All those in favor?
Yes.
Aye. Okay, motion passed.
I was not there, so I abstain.
Oh, okay. 5 in favor, 0 against, and 1 abstention. Okay, moving on to public forum. If anybody in the audience would like to speak to us on an issue that is not on the agenda, please fill out one of the pink forms over there and give the form to Michael, and he'll get it up here. Okay, there's not a whole lot of action there. So we'll move on to our next item, which is a continuation of a type 3 legislative public hearing from August 11th, 2026. This is a hearing on code amendments regarding variances for driveway grades on flag lots. This is Planning Action PA-L-2026-00020, and the applicant is the City of Ashland. The request is to amend AMC 18.5.3.060, variances for flag lots, to allow variances of greater than 18% for flag lots created as legal lots of record prior to the 1997, when the city adopted its hillside development standards. Currently, AMC 18.5.3.060 allows grades on flag lots up to 15% and variances up to 18%. And so the recommendation is that we make a code amendment. We're asked to recommend a code amendment to the city council. Because this is a legislative public hearing, I'm not going to ask about ex parte contacts or site visits, but I would like to recognize and thank the following people for submitting written comments to the Planning Commission at this continued public hearing, demonstrating that when residents know about an issue, they can make comments. Molly and Peter Kilfer, sorry if I mispronounce your name. Evgenia Andrianova, Len and Karen Eisenberg, Cindy Peer, Carrie Mastane, Pamela McLaughlin, Kent McLaughlin, Kurt Chappell, Gary Schaff, John Kletzel, Catherine Ellison, Troy Brown, Margaret Young, David Paul Auersler, Dee and Rob Collins, Jim McCarthy, Doug and Linda Smith, Jamin Giersbach, Rogue Advocates, Bob Hilton, Matthew and Mary Huff, Jay Reek and Sarah Sammy, William Sherlock, Zach Mitke, and Emil Sandowski from Hutchinson and Cox Attorneys for the McLaughlins and the Eisenbergs. Charlie Hamilton, and Chris Hearn, attorney with Davis, Hearn, Anderson, Selvig, and Naris, representing Brian and Stephanie DeBoer. Thank you all very much for taking the time to make comments to us. I'll move on now to staff presentation. Derek?
Thank you, Chair Werner. So just as background, for those that may not be up to speed on where we are in the process, the Planning Commission considered and rejected staff's initial recommended language to address driveway grades at the last meeting on August 11th, and continue the hearing in the record to tonight, August 25th, to further discuss and deliberate. The previous commission discussion included addressing ordinance language to better distinguish between pre-hillside ordinance and post-hillside ordinance lots for clarity and readability, whether to include an upper limit on driveway grade variances for pre-hillside ordinance lots that cannot otherwise meet the standard, and that standard would be the 15% base driveway grade, clarifying the variance considerations in the standard versus relying solely on the variance criteria in AMC 1855, and then whether relief from the driveway grade standard should be dependent on when the property was purchased and what the driveway grade standard was at the time of purchase. There was some discussion last time about looking into property records. In staff's research, 7 of the 13 lots in question have changed hands since 1997. In your packet, you have some revised language addressing those key points. And I'm just going to go through quickly. The general standard in F1 would be flag drive grade shall not exceed a maximum grade of 15%. 2 provides an exception for lots created after the hillside standards. For a flag drive serving a lot created on or after the effective date of the hillside development standards, ordinance number 2808, adopted December 3rd, 97, including a lot created through a flag lot partition, a variance may be granted for a grade in excess of 15%, but no greater than 18%. Section 3, an exception for lots of record predating the hillside development standards for a flag drive serving a legal lot of record created before the effective date of the hillside development standards, ordinance number 2808, adopted December 3rd, 1997. A variance may be granted for a grade in excess of 15%, and we've included an option here to say, but no greater than, and the number we've put out there for consideration is 25%. We've included a cumulative length limitation. The cumulative length of all sections of a flag drive exceeding 15% grade approved through a variance under subsection F2 or F3 shall not exceed 200 feet. In terms of fire code compliance, a flag drive approved under a variance under the subsections F2 or F3 remains subject to fire apparatus access requirements of the Oregon Fire Code, including any approval required by the fire code official. And then F6 addresses the variance criteria. What staff are proposing specifically, a variance under F2 or F3 shall meet the criteria for approval in Chapter 1855 variances. Circumstances supporting a variance under this subsection include, but are not limited to, a demonstration based on a stamped engineer's drawing that no alignment meeting the general 15% grade standard of this subsection can provide vehicular access to a buildable area of the lot, or that a steeper alignment would better avoid or reduce impacts to natural or physical features on the site, such as water resource protection zones, trees, rock outcroppings, or areas best left in an undisturbed natural state. In evaluating a variance under this subsection, the approval authority may consider unique or unusual site conditions, including topographic constraints, access limitations, and the avoidance or reduction of impacts to natural and physical features in determining whether the requested grade is the minimum necessary to reasonably develop the lot while minimizing site disturbance. The fire code officials shall make a recommendation on each variance application regarding fire apparatus access and fire and life safety, and the recommendation shall be considered by the approval authority. And in terms of F6, there's an alternate F6 that I distributed to you that Chair Werner had proposed. So there's slightly different language there to consider as well. The memo that you have in your packet also gets to ownership triggers with the discussion of possibly limiting this to lots that have remained under the same ownership since the ordinance took effect in 97, which again was 7 of the 13 lots. In our assessment, the problem with that approach is that land use rights and limits in Oregon almost always run with the land, not with a particular property owner. Grandfathered and non-conforming uses rights typically transfer to new owners for that reason. If relief from the driveway grade standard were to be conditioned on continuous ownership, a lot that in the 97 owner could build on today would become unbuildable the day it's sold or inherited, which recreates the same no relief problem the exception is meant to fix and pushes it onto buyers or heirs who had nothing to do with when the lot was created. This would raise the city's takings exposure, and rather than lowering it, it could be difficult to administer. It could be difficult to administer since staff would need to track chain of title, which we aren't involved in as an eligibility question, with the pool of qualifying lots shrinking over time until none were left. And that's similar approach was taken with Measure 37 a few years ago, making relief dependent on when an owner acquired their property. It was essentially an ownership date entitlement, created enough legal and administrative problems that voters had to pass Measure 49 a few years later to rein it in. For staff, that history of Measure 37 is a useful caution. Keep in mind the fairness argument for favoring longtime owners over someone who bought a steep lot knowing its limits is a real point the commission can weigh, but it runs against the overwhelming practice in Oregon land use law, and staff's recommendation would be that the entitlement should run with the land so we're not creating unbuildable lots with no path to relief for future owners. And you also have distributed with materials there a memo from Commissioner Linninger speaking to that issue as well. So with that, staff have a recommended motion here, which we can bring up to the screen when you're back to that point. And I did want to note, whatever recommendation that you make tonight, this item is scheduled to go back to Planning Commission for to City Council for public hearing and first reading on October 6th.
Is there, so P&Es are type 1s now, so if there was a variance to be approved on those lots, would that come before us or not?
So
If somebody was doing F6,
if somebody was doing a variance that was discretionary, it could be appealed to the Planning Commission, yes.
but it wouldn't come to us
It
unless it
wouldn't
was
come to you
appealed?
automatically,
And
no.
would it be noticed under what we're talking about?
I mean, I think we still have to resolve that issue with the final, but in staff's view, there's going to be a noticing requirement that's contained in state law.
Okay, thank you.
And is that the 100 feet or 200 feet?
100 feet.
100.
Sorry.
No.
That's 100 feet from the property line of any of those lots.
Yes, so it's buffered based on the perimeter of the lot, 100 feet, and whatever is touched by that 100-foot radius is pulled in as a notice.
So in some cases, that might only be 2,
Depending on right-of-way, it could only be 1, yeah.
right? Okay, thank you.
Anybody else have questions for staff? Go for it.
Thank you, Chair. Hi, Derek.
Hi.
I want to ask you about how the variance procedure under 18.5.5 works,
Yeah.
because I don't have any experience with it. Are those approval criteria exclusive, or do they consider other parts of the code kind of by implication? Like, for example, where they might apply the development standards for hillside lands?
So typically, a variance is specific to the request being made. So if you were requesting a variance to the driveway grades here, that variance wouldn't take in other things that might be related. So for instance, if you were doing something in hillside lands that triggered disturbance of lands over 35% and needed a variance to that, that would actually be also an added exception to the hillside development standards. So typically the variance is specific to the request, and you may have multiple variance requests or a variance and an exception as part of one application.
Okay, so I'm hearing that it would be application dependent,
Yes,
and that probably a variance request isn't going to happen in a vacuum, right? It's going to be part of a broader application that would include a lot more than just driveway construction. And if those occur on slopes greater than 25%, then the hillside lands development standards would apply independently.
yes.
Okay, cool. And in every case, the variance approval criteria provide that a variance must be the minimum necessary to
Correct.
address the unique physical conditions of the site. Is that right? Okay, so the language of F6 in the draft ordinance, that's just talking about how an approval authority would get to that minimum necessary determination, right?
Right, and the variance criteria in 1855 is kind of generic catch-all. F6 is trying to point you at specific examples that might apply where you're dealing with a driveway. And you'll see that elsewhere in the code, although I can't think of anything off the top of my head, but you'll see it elsewhere where a specific thing says may be sufficient for a variance to demonstrate that the lot was legally created or something like that.
Okay, so just to dispel some heartburn, I think, that exists in the community, this is not about exempting anything from existing standards other than that 18% hard cap that exists on flag driveways, right?
Right.
Okay. And is it correct to say that none of these 13 flag lots that have been identified by mapping could be accessed from a public road unless the city makes a variance procedure available for that 18% limit?
I can't say that for sure. The mapping that occurred looked at the general slope of the property based on GIS data, but we didn't go to the effort of how you might engineer in a driveway to meet the grade standards. It's entirely possible that that number 13 could not be that high. You could have something where they could hit a driveway at 17 or 15. It's just based on GIS data, it seemed like a good likelihood that those would need relief.
Okay.
Yeah, I would note of the 74 original lots that were vacant on hillside lands identified, these 13 lots were seen to necessitate a driveway length in excess of 50 feet, which is what triggers the flag drive standards. So those are what was presented before this body.
Okay, good. Important clarification. Thank you. And how many times in the past have applicants sought a variance to this exact standard since it was adopted in 1997? Has it happened more than once?
I can't think of them off the top of my head, but I would say 5 or less.
Yeah, it's 3 or 4, because I've done 3 in the past.
Awesome. What I was hoping to hear is more than one. In granting such variances, where they're granted, the planning assumption always has been that those platted lots need reasonable access because they were designed and platted to abut a public street, right?
Right.
Yeah, so that's key not only to the owner's access, but also to fire apparatus in order to realize the purposes of creation and zoning. Is that right?
Right.
Okay, cool. Thank you very much.
Anybody else have any questions of staff? Commissioner?
Up to you.
Related to that and acknowledging that I was not at the last meeting because I was unable to be here, if we could go back to the basic reason why this is coming before us, because there are a lot of assertions about why that I think it's really important to be clear about on the public record.
Sure. So in terms of The Hillside Ordinance took effect in 1997, was adopted through Ordinance 2808. That has yielded a code now that has a limit on new flag drives of 15% as a maximum driveway grade, and it provides for a variance up to 18%. As Commissioner Linger mentioned, we have historically allowed variances to go beyond that when it's not possible due to topography to meet that 18%. If it's not possible to get from the road to the buildable area of the lot because topography exceeds 18% and there's no other alternative, variances have been approved in that case. In April of last year, LUBA made a determination on a specific application that 18% maximum in the code is a firm limit that we can't go beyond in any case, even with a variance. So the situation we're in now is that the city has looked at, through planning staff using GIS data, 74 lots where this could be an issue, and identified 13 where there's a likelihood that existing vacant lots could now be rendered undevelopable by that LUBA ruling. And so the code language here is coming forth to try to address that and provide an option when there's no other alternative available to access those lots, rather than letting that code ruling from LUBA rule them undevelopable.
So is it, go ahead,
I was
Brad.
just going to elaborate that subsequent to adoption of Ordinance 2808, the Hillside Ordinance, that flag drive standard does apply to any newly created lot. It's under the flag partition chapter. So new lots could not be created to create new development opportunities unless they could demonstrate a drive that met the 15% or up to 18% with a variance. So this ordinance amendment was specifically carving out a recognition for pre-existing lots, as Derek had mentioned.
So is it fair to say this is addressing a logical gap that has existed since 1997?
Yes.
And to the earlier question, has come up in other circumstances with other lots, and now here we are today, but it has a decent history and again is, basically been identified as a gap in the ordinances
That's correct.
for multiple properties.
Go ahead.
Thank you, Chair. Just to be clear, are we changing the measuring stick on how the 100 feet is measured? I heard some rumble that,
So the 100-foot notice requirement is part of Ordinance 3307. It's not before you this evening. So the 100-foot notice requirement, this committee had already made a recommendation to council, and they reviewed it on August 18th.
right, I apologize for the confusion. I was talking about the way the driveway is measured, not the distance for neighborhood
Okay.
notification, which I was present. I think I actually made
Sure.
that motion.
Yeah.
So I'm aware of it.
Okay.
So is the way the driveway is measured in this particular variance scenario, is that being changed too, or no? There's no change to what constitutes the initial driveway distance and the new driveway distance? Is that changing?
It is not addressed in this ordinance. There is public comment that we received that refers to section F4, the cumulative length limitation.
Yeah.
Our existing code stipulates for flag drives that any portion exceeding 15% grade approved through a variance shall not exceed 200 feet. Because we created two subsections, one for pre-existing lots and one for lots created after 1997, we incorporated into that section through a variance under subsection F2 or F3 shall not exceed 200 feet, but there is comment in the record from Mr. Hearn that indicates that does not provide relief for pre-existing lots by incorporating F3 in that provision. But we're not changing the pre-existing driveway or new driveway. Those terms aren't being addressed in this ordinance.
Yeah, have anything? Maybe?
What's the format? Do we have discussion when we're in it?
We're asking staff questions now.
I get that.
Okay. So it's not technically discussion. That would be after the public hearing's closed.
Chair.
Yeah, go ahead.
Brandon, Derek, when you looked at the GIS information, those roughly 13 properties, are they primarily owned by 13 different people? Or are they all owned by one person?
I looked at the ownership data. I honestly can't tell you, other than I can say there are a couple that are owned by the same person.
Okay.
And there are several that are owned by a neighboring property owner who lives there.
Lives next to him.
So they're maintaining a larger home site. So they have a vacant lot that's owned by the neighbor.
So it's safe to say these 13 properties are spread throughout, owned
Yes.
by the general public, all individuals equally?
Yes.
Okay, thanks.
Tell me whether this is a fair question or not, but in your estimation, given the analysis that's been done of these lots, are they generally amenable to development for affordable housing or not?
I would not picture, absent subsidy, I'm not sure anything is amenable to affordable housing at this point.
Hillside lots are not amenable to affordable housing, period.
I just wanted to hear it from someone other than myself.
But under state law, any housing now is considered needed housing, so.
Thank you. Derek, could you speak to the purpose of in F4, proposed F4, the purpose of the 200-foot length limit? Like, my understanding is that it's from the existing standard.
It's from the existing standard, and I think it's intended to limit the amount of disturbance of those steeper slopes to what was seen as a reasonable figure.
And that's sort of rooted in the comprehensive plan, right? The goals and policies to deal with steep slopes and erosion concerns with respect to, and stormwater drainage.
Yeah, the hillside ordinance is implementing the comp plan vision. So, yeah, all of the standards are ultimately implementing the comprehensive plan.
Okay, thank you.
I thought that the 200-foot had something to do with fire access as well. Like, maybe I'm making this up, but as I recall when we did the notorious one, has to do with a run of 200 feet and then some leveling, and then so that it's about vehicle stress or access.
It could well have, the fire code officials' review is separate, but it could also be tied to fire requirements, which get to how far they can run a hose, firefighter access, work area turnaround, distance to a hydrant, all of those things. So, there are a number of different requirements through fire code that also look at distance.
Go ahead, John Marr.
Thank you, Chair. Do we have any data on what the curve looks like beyond 18 degrees? So as you go from 18 degrees to 20, to 22, to 24, heaven
It's
forbid.
not degrees, it's percent. It's
Percent,
different.
sorry. Good clarification. Do we have any data on actually what the crash rate is, likelihood to go off the road, likelihood to slide in weather? Is there any data on this?
Not before you, not in the packet, nor in my memory. I do know that, just one point of note, what we're talking about is driveways serving individual lots. So it is not road data that would be tracked by our police, because it wouldn't necessarily trigger if somebody went off their own driveway, they may not report it onto their own property, and it wouldn't be a crash with another vehicle on a road.
Okay, so that's a fair point, but nonetheless, we know vehicle goes up a slope, it's more or less likely to slide off that road than not, whether it's a driveway or an alleyway or a freeway, right?
Steepness is steepness.
Thank you, Chief.
You're welcome. Okay, shall we move on to public comments? Thank you very much, Derek. And now we have, on Zoom, we have Jay Reek and Emil Sandowski. Are they available?
Hello, can you hear me?
Yes, could you give your name and you have 3 minutes.
Hi, this is Jay Reek from 230 Strawberry Lane, and I'm speaking on behalf of myself and Sarah Sammy. Thanks to the Planning Commission for your time, and also thank you for thoughtfully rejecting the previous proposal. I've got a few comments to make. One, despite the conversation, this proposal doesn't address the Commission's request for a maximum grade limit. The proposal has no upper grade limit for pre-97 hillside lots. And really, this code change is creating a problem that actually doesn't exist by proposing a code without an upper grade limit. And yes, the meeting packet includes optional language for the Commission to adopt a 25% upper limit, which we all intuitively know this is dangerous. It's a statewide outlier. And of course, it's just a touch higher than the proposed 24% grade proposed for 231 Granite Street, which was the LUBA appeal, and a lot that is referred to repeatedly in the written testimony that I trust everybody read for tonight. You know, we already have a limit of 15% and a variance for up to 18%, and this is designed for safety, as Mr. Mayor is noting, and no new upper limits need to be adopted. And also, the commissioners asked specifically for a list of the hillside lots that were still owned by people that own the lots, and Commissioner Herron just asked about that, but that list wasn't provided. And the commissioners wanted this so they could limit any exceptions to only those lots, not lots that have been purchased since then. And Commissioner Leininger also explained that move will decrease the city's risks for taking suits. If you, again, reading through, I just had a chance to look at the notes for tonight. The neighbor's attorney's info also shows that there is no substantial risk of taking suits for the city around this, and this risk is overstated too. And it seems to me that making an exception to one of the hillside standards codes is opening up the door for Ashlanders to seek exceptions to all the other hillside code standards as well. And the written testimony even has examples of neighbors who have had to follow those rules in the past. And we all need to follow the rules, as testimony was given last time too. And this could be a slippery slope, if you'll forgive me for saying that, for increasing risk to our city. Also, with the current drive limits, 231 Granite Street, I just want to say as an aside, it does have economic value. And we know that a neighbor has an offer to purchase it for its 2023 purchase price plus 10%. And also all the pre-97 hillside lots have economic value also. The same neighbor has offered to help the city purchase those lots. So I don't think that loss of economic value is a problem here either. Like the commissioner asked, like, why is this here? Like, what in front of us? What's the actual problem that needs fixing? And much of the testimony points out that this is about favoritism for the owners of 231 Granite Street. And by the way, their attorney's notes weren't published before the meeting tonight, so I think the public didn't have a chance to see that, and also the public didn't have a chance to see apparently some code revisions that were just given to the council tonight, so that hasn't been reviewed. Anyway, let's not get sidetracked by this proposal. It increases risk to the city, the citizens, first responders, and the community at large. I think this is an easy call for the commission tonight. Nothing substantial has changed in the city's proposal, so it should be rejected again. Thank you very much.
Thank you. Emil Sandowski? Is, thank you.
Hello?
Hello? Yeah, please go ahead and introduce yourself, and you have 3 minutes.
Thank you. My name is Emil Sadovsky. I'm here representing Kent and Pamela McLaughlin and Lee Eisenberg. I want to thank you for taking the time to hear the public's comments today and the careful deliberation at the last meeting. I've spoken at some length about legal and policy issues surrounding this proposal. I won't go back into those. The written testimony I submitted today has an attachment to the previous letter we submitted. For the most part, the language changes to the amendment do nothing to mitigate any of the issues we raised before. And you can review those at some length there. Pretty much no matter how you shuffle the words around in this standard, allowing flag drives in 18%, in excess of 18% is a stark departure from a well-founded trend in Oregon and Ashland towards safer and more resilient development against wildfires. At the last hearing, you discussed the issue of takings risk and inverse condemnation at some length. I want to push back on the idea that the idea from the staff that carving out post 1997 lots is going to have some effect at increasing their inverse condemnation risk. There are two standards that are available to claimants who are trying to seek compensation for regulatory takings. One is the Oregon constitutional standard, and one is the federal constitutional standard. Under the Oregon constitutional standard, a complete elimination of value of the land is required. And under the federal one, that's a complete elimination of the value is required in most cases. But in cases where the value is simply reduced, these claims can sometimes be available, but when the owner has a reasonable expectation that what they're doing, the development they want to create, should have been allowed, that's one of the key issues in deciding that. So there's the idea that you're increasing your exposure by carving those lots out is, I think, completely in opposite to the law that exists. But at the end of the day, this is a legislative decision, and you can't weigh, litigation is uncertain, you can't weigh all of the risks in this kind of procedure. Up until this point, Ashland has been an admirable example of pivoting its municipal policy to protect public safety in response to Oregon's ever-increasing threat from wildfires. This proposal will lower the city safety standards, and it does so. I mean, there's been some discussion of this today, but this is primarily to the benefit of a single wealthy owner who has objections to those standards. Passing this proposal will send a message that Ashland citizens are their safety and their health is less important than the needs of a very small class of wealthy owners. This is an opportunity for the commission to tell Ashlanders the opposite, that their safety can't be bought. So I urge the commission to reject this proposal, and I thank you for the time you've taken to listen to my comments and read my written testimony.
Great, thank you. And now we have people who are actually here in the audience. Ronald Parker, would you come forward and use the mic over there? Introduce yourself, and you have 3 minutes.
My name is Ron Parker. I live at 301 Schofield Street, northwestern part of the city. And just, we sent in some documentation that wasn't included in the list of names that you read off earlier.
Okay, we'll investigate that.
My wife, Pam, and I are ordinary citizens of Ashland and have lived here since 2004. We believe that the rules, codes, and ordinances that have been made should be followed, especially long-standing ones. We oppose the proposed changes to the driveway grades. There should be no exceptions for special families. commission to just say no if these situations come up concerning driveway grades. Thank you.
Thank you very much. Our next speaker will be Troy Brown. Please introduce yourself, and you have 3 minutes.
Thank you. Troy Brown, 345 Inlet Lane, Ashland. Number one, this seems to be odd that we're here, number one, for 2 reasons. This was a denied last week, and this week we're back at a working session rather than a regular session. But it is incredibly odd. Also, the 18% grade was done through a study, and there was a reason that their 18 grade was made at the cap. This now seems you want to change the cap based upon how you feel that somehow or other should be higher. So I'm totally against it. Anybody that has any dealings with the planning commission understands that most of these changes need to be done with clear thought that actually have reasons. And so far, I have heard no reason other than that 13 lots maybe you can access. This is not a reasonable change. The 18% was set for lots of standards, none of which are put on the table for the 25%. Thank you.
Thank you. Our next speaker will be David Oursley. Auser? Sorry. Please introduce yourself, and you have 3 minutes.
Hi, I'm David Osler, 252 Strawberry Lane. I want to also state that I think that this smacks of special treatment. My experience when I built in 2007 was that I had a city employee, Mark Knox, who's come by my property and tell me where I could not build, what trees I could not cut down, and other details of the hillside ordinance that I had to abide by. And I abided by it. That's the way it was. I have a rather large lot. I wasn't able to use a good portion of the lot, which would have been much superior, but I didn't come to you all and claim that I needed special treatment, and nor did I sue you for takings. Second point, why 25%? Why not 50%? Why not 100%? I mean, we can go to ladders. I mean, you have not defined in this ordinance is remarkably vague, or the changes are remarkably vague. Just by way of comparison, we build hiking trails, and we try to keep them to 12%, which is about as steep as you can walk comfortably. Most of them stay down around 10, 8%. So when you're talking about 25%, you're talking about something that is not even comfortable walking, not with a backpack, not even comfortable walking. The fact that you said 25% in 200 feet, look, this was written for the divorce, maybe by the divorce, and that is really quite scandalous. Third thing, takings does not apply when they bought the lot knowing that it was unbuildable. All of us neighbors around there have known about this lot for a quarter century and have known it's not buildable. The divorce bought it knowing it was not buildable. They just figured that they had different rules than the rest of us. I don't see how we can say this is a takings problem when there's an offer on the table to give them their money back. And with the other lots, maybe we should be considering whether it was a mistake and we should pay them some reasonable compensation rather than having dangerous building codes. Lastly, precedent. What I'm taking from this is that none of the ordinances that have been written since I bought my property can be enforced on me. It seems that it follows that even if we're talking about grandfathering in, it seems to me that the slippery slope here is that your special treatment of the divorce is going to make it so the rest of us can sue you for takings, because this is a precedent you're setting. Thanks very much.
Thank you. Okay, we have exhausted the people on Zoom who wish to talk and the people in person who wish to talk. So, are there any planning commission questions for any of our public citizens? No? Okay. Then I will move to close the public hearing and the public record. So now we're into deliberations, and we have a lot in front of us. I will clarify that we did adopt a motion at the last meeting to reject the ordinance, and that probably was in error on our part because we were actually, what we were doing was putting it on pause and saying we don't want the wording in the ordinance, but we do want some other wording, and let's deliberate and figure out what that other wording is. So now we're at the point where we are talking about what the other wording might be. Clear as mud?
So
Go ahead.
I do believe it's a taking to not allow those lots that were created before the hillside ordinance, before the ordinance that was defining the slopes of the driveways was created. I don't think it's special treatment for certain people that you guys, everybody seems to think it's about. I've worked on a couple of lots that were not accessible based on the hillside ordinance and the driveway ordinance, and working with staff and with engineers came up with the least possible variance from that. The other language I wanted to respond to is people were saying it's an exception. It's not an exception, it's a variance. It costs a huge amount of time and effort to actually propose those variances and show that you're doing the least amount of damage possible. And that's all I wanted to say. I just wanted to, it's something that's been going on for a long time, and I actually think that F6 clarifies that and solves it. So that's my opinion.
Go ahead.
Thank you, Chair. So the proposed revision does not address the problem. On August 11th, this commission voted unanimously to reject this ordinance as written, as proposed. Staff has since restructured the language, added an optional 25% cap, and required a fire code official recommendation in the record. These changes are cosmetic.
And the engineering,
I'm not finished yet.
okay.
You'll have your chance. This is the same legislation. The question before me is the same. Should the city of Ashland create a new variance pathway to enable development on steep wooded, fire-prone hillsides at the edge of the urban growth boundary? This commission has already answered no. Nothing in this staff report changes that answer. This remains loophole legislation that benefits the few at the expense of the many, and it contradicts both the direction of the comprehensive plan and the priorities of the housing production strategy. We know what is prompting this ordinance. This is not citywide legislation that happens to reach one property. This is one property's application drafted into citywide legislation. In April 2026, LUBA remanded a city's decision approving a driveway grade variance, concluding that the code as written does not authorize the city to grant that variance. The proposed language fits the most recent application exactly, as has been pointed out. The optional cap is in subsection F3 is 25%, just above the 4% drive, and the cumulative length limit is in F4 is 200 feet, the approximate length of that drive. A 25% cap is 7 points above the 18% maximum code that the code allows anywhere else in Ashland, even by variance, and 10 points above the 15% generated general standard. It's a 66% increase over the standard. Size to fit one application. This so-called limit is not a safeguard, and 7 of the 13 eligible lots have changed hands since 1997. These are not, in the main, longtime owners trapped by a rule change, but purchasers who acquired steep lots with full knowledge of the standards that govern them. A lot that requires a variance is not a buildable lot. It is a constrained lot seeking an exception. The city's own buildable lands inventory confirms this. Lands with steep slopes are excluded from the inventory as constrained. These lots are not counted toward Ashland's housing capacity, and they are not needed to meet it. It gets worse when you realize who will decide these variances. As staff confirmed at the August 11th hearing, residential variances will largely be decided administratively by staff under House Bill 4037, with appeal rights available only to the applicant. If this loophole legislation is passed, these variance decisions will not come before this commission, and neighbors will have no avenue of appeal, not locally and not before LUBA. We would be creating a discretionary exception while giving up the public's ability to review how it is used. Number 3, we have already been down this road. I would remind the commission of 329 Granite Street, where a flag drive loophole was exploited to eviscerate an entire hillside, generating hundreds of truckloads of gravel and cement block over months for the production of one expensive single-family home that in net caused dislocation. The math does not add up. You get 3 or 4 new individuals, you lose 6 to 8. Number 4, this ordinance is unnecessary to meet any housing goal. The city's own numbers are clear on this. The 2021 housing capacity analysis identifies a need for 858 new dwelling units between 2021 and 2041, against a capacity of 2764 units within the urban growth boundary. Every one of them is on legal, unconstrained, buildable land, developable under existing standards without a single variance. That is more than 3 times the 20-year need, with 1,455 units of capacity inside city limits alone, and a surplus in every single plan designation. By my calculations, Ashland can meet its housing growth goals for the next 10 years several times over just within the CFAs and the Transit Triangle, which is exactly where housing production strategy directs growth. The housing capacity analysis is also clear about what kind of housing Ashland needs. This ordinance produces the opposite: large single-family homes on the fragile, fire-prone edge of the urban growth boundary, accessible only by long, narrow, winding, steep shared flag drives. It serves no identified housing need in the analysis. 13 lots is not a housing strategy. It is a special accommodation. And even though the plan states that all housing is created equally, we know, and I can tell you from the housing subcommittee, all housing is not created equally. We have a comprehensive plan. It's a good plan. It's been well vetted, and it's working. We should not undermine it just because we made a mistake in the past and allowed too many dangerous driveway exceptions. We should learn from it, and we should prevent that going forward. So, in closing, thanks for your patience. The benefit goes to a handful of lot owners. The risk and the cost fall on the whole community. This is not a trade that the commission should endorse. This ordinance is contrary to state law, cuts against the city's comprehensive plan and the community wildfire protection plan. The housing capacity analysis and the housing production strategy tell us it is unnecessary. Our own experience on Granite Street tells us what problems in the community and neighbors, and for the neighbors it will produce. I urge my fellow commissioners to vote again, no, as we did on August 11th, for common sense and for the well-being and benefit of the many over the interests of the few and the safety of the community as a whole. Thank you.
Thank you. So, you're recommending that we don't approve these changes. So if we don't approve the changes, then the existing language still stays. And there is a maximum of 15% with a variance allowed to 18%.
I think that's consistent with the rest of. Sorry, I think that's consistent with the rest of the lots in Ashland that are of comparable scope, dimension, scale, location.
Okay.
It seems logical to me, and it seems fair.
Okay, so if somebody does bring an application to staff, or maybe even to us, then then the staff is put in the position of saying, no, you can't build on it because it's not within the limits. And so then, so staff is, let's presume it's staff because the way things are going. So staff is going to turn them down. And the property owner then is probably, they're going to have some options, one of which would be to sue the city for not allowing even one house to be built on their particular lot.
They'll appeal, sorry.
I think we heard very clearly that the taking risk is low. I mean, there's a separate argument to be made around the risk of taking here. I think setting a uniform, consistent standard of 18 degrees, which is based on evidence, is the right decision for the city. That's what I'm saying.
Okay. Carrie?
If they were denied by staff, they could appeal to us. That's the path.
Mm-hmm.
If they were denied by us, I suppose they would go to council or go to LUBA. Okay, so they'd have to
So
go
they
through
have
the
a
same
path.
process.
Okay. Commissioner Jen?
So Commissioner Mauer. Mar, thank you. Is the net of your point of view that the same standard should be set for properties that were pre-1997 and post-1997? Does it boil down to that?
Yeah, there should be one standard and it shouldn't exceed 18%. That is my recommendation.
Okay, thank you. Just trying to make sure I understood all of that exposition. And it's Jen, not Jane.
Does anybody else have any comments at this point, or? Go ahead.
Thanks, Chair. And that's a tough act to follow. I'm grateful to the commissioners for agreeing to continue this hearing rather than just disposing of the matter last time, because it afforded me 2 weeks of study to try to figure out what lays at the root of a lot of the public comment and testimony that we heard. All of which I have taken to heart, including tonight, and tried to apply to the facts of this. My core concerns going into this are, first, to ensure that the land use ordinance implements the comprehensive plan. That's foremost. And then second, to protect city taxpayers from liability for taking a private property. And so on taking, because it's a live question, folks are talking about it tonight. I think that some variance procedure is a good idea. Because leaving the code as is would create some new level of certainty, not on every lot, but apparently on some lots. And it's going to be a factual determination about what level of certainty that is. But I think it's foreseeable that some level of certainty would exist without a variance procedure. That certain lots would not have access for private vehicles or for fire apparatus, even though those lots were platted, created to abut a public road. And, as I described in my memo, the right of access comes with the title of the land when it is platted to abut a public road. That is the common law of property in Oregon. And so the local government can condition the development of that easement appurtenant, but it can't extinguish it without a taking. And that creates real liability to the city taxpayers. So I think that leaving the land use ordinance unchanged could ripen a taking claim under one of two factual scenarios, depending on on the level of loss of economic value or use. One scenario is a lot more disadvantageous to the city than the other. Again, not to prejudge any particular case, there is no hard and fast rule for what is a taking and what is not, what constitutes total loss or not, but the necessary facts to plausibly plead a takings claim, a ripe takings claim, exists at the conclusion of this type 3 legislative procedure if no variance procedure applies to the pre-1997 platted lots that abut public roads. So I'll wrap up. I also think that all these flag lots need to be treated the same in a variance procedure. We cannot distinguish by establishment of a state. Some commenters and folks who offered testimony even tonight make a facially plausible argument to apply that distinction from the Oregon Revised statutes, but that applies to a different takings context than what would exist here. Under the federal Constitution, that distinction would not survive judicial review, and I invite the commenters to review the Palazzolo v. Rhode Island precedent of 2001, and also the U.S. v. Dickinson precedent of 1947. Distinguishing the federal and the state context here is essential. And I think the takings question is actually plausible in a federal context here. I'll save my comments for what a variance procedure might look like if it seems like the commission wants to go that direction. Thanks.
So you're arguing that the commission should be putting some sort of variance procedure with or without a cap on the slope, specifically into the pre-1997 lots.
Yeah, for the pre-97 lots, I think that's where the variance procedure belongs. And I would prefer a cap, a clear and objective cap, if we can justify one from the comprehensive plan or the existing code. Now, I noted with interest that staff informed us that the development standards for hillside lands remain effective, independent of this variance procedure. That includes a cap, a hard cap.
What?
Of 100-foot length on slope above 35%, is that right?
Correct.
Mm-hmm. So that's one existing hard cap that's in the code. I'm not saying I love it, but it is a hard cap.
Crossing 35%. Yeah, not that the driveway would be.
Yeah, so a driveway installed across lands that are in excess of 35% could not disturb more than 100 feet of length. on
Of
the
that.
severe constrained lands.
Of that 35%.
Correct.
Hang on, John.
And I'm certainly open to other ideas about how to accomplish a clear and objective limit that would be consistent with the comp plan. And, hey, if the commission wants to recommend to council not to do anything, that's great. It's just got to come with, I think, a clear awareness that we might be costing the city some bucks.
Okay, so how do you get, how do you get a lot or a driveway steepness determination from the 100 feet across 35% slope? Is there any way to predict that?
I don't think that's a steepness question. That's it's going horizontal on
Yeah.
a steep slope, so we're not talking about the.
Right, yeah. Okay, go ahead, Commissioner
Thank you,
Miller.
thank you, Chair. I just want to respond to some of the kind of foundational statements in my esteemed commissioner's argument, and just clarify them with staff. So if there's a lot and there's a road running along it, is it buildable?
For the most part, there are properties that are parks or other designations that are not considered buildable, but
Okay.
a residentially zoned lot that has access would be considered buildable.
Okay, so let me restate my question. It has a 45-degree slope and it's covered with whatever and it's unstable. It's just because there's a road running next to it doesn't necessarily state that it's buildable.
The land use ordinance explicitly states that all lots have to have a buildable area, which is considered less than 35, but pre-existing lots that don't have such a slope are considered buildable for one house and one accessory unit or duplex unit.
Okay, so maybe we're talking about terms. So if it requires a variance in order to be built, still buildable? Technically buildable,
Yeah.
but it requires a variance. So we have an existing variance, I understand, and it's 18%, right? 15 to 18. You can go to 18 with the variance. Is that correct? So we have an upper end. That number is 18. There's your answer, 18.
You can go to 20 for 50
So
feet?
driveways that are less than 50 feet long are not held to the flag drive standards.
Okay.
And they have a maximum grade of 20% without a variance. So a 49-foot driveway could be 20% grade. If it wanted to go to 24% grade for a 49-foot long driveway, it could get a variance to that standard. What we're talking about tonight is specifically flag drives, which are driveways that are in excess of 50 feet in length.
Great, so thank you for that. So is there any reason why a flag drive shouldn't conform to the same driveway standard? Why not just have it conform?
If it complied to the driveway standard for drives less than 50 feet, it would be a 20% slope with no cap on maximum grade.
So I'm making the argument that we should just maintain the existing code that we have. I mean, there's clearly been some analysis gone into establishing 18%, 20%, 50 feet, 20 feet. And those are the standards that we should enact. We should certainly, well, first of all, I think the takings claim is dubious, and we could have a whole session on that. There's been no takings claim to date. This code's been around a long time, there's no takings claim.
I think that's a really important point, that the statute of limitations ran on a takings claim in 2003. But if I were a plaintiff, here's how I'd argue it. I would say that the facts needed to prove a claim don't exist until the city says no variance.
Well, there's always risk. That's just the nature of it, right? So that's my recommendation is that we reject this as written, and that if we were to create our own legislation or modify legislation, I haven't drafted it, but I would say have it adhere to the existing code.
Can I offer a thought on that?
Sure.
I think it's really constructive. I'm aware that the Eisenberg case is still live in the Oregon court. The defendant interveners in that party timely petitioned for review by the Oregon Court of Appeals. They had oral argument on that appeal 2 days after we last met. And it's still possible that the court will find fault with the Luba holding. It's not a foregone conclusion that the city's existing presumed legal position is cast in stone. And because the city council is not scheduled to address this until October, maybe we can give the court some time to work and tell us whether or not the Luba order sticks, which is what creates the circumstance underlying this proposed ordinance. We've got 2 meetings between now and then, and that's some time to possibly craft an alternative that would better answer the needs of the present circumstance. As long as this legislative hearing continues, local government is exercising its reasonable discretionary procedures to address this flag lot driveway issue, and there's no possibility of a taking claim. So I think maybe we ought to consider reconsidering this.
So staff, what if we continue this public meeting again, public hearing again? No, actually, we're in the public meeting part.
So at this point, the public hearing and public record has been closed. So to continue the meeting for further deliberation, any deliberation to provide a recommendation to the city council should be concluded prior to our preparation of packets to go to council. Their meeting is scheduled for October 6th. So provided your second meeting in September is the extent of a continuation that you could do, otherwise it will go to the city council without a recommendation from the planning commission on October 6th.
Thank you, Chair. I mean, given how City Council weighed in on the discrete issue, I think we, as the Planning Commission, should send a very clear message on the general position regarding this. I'm not confident that they're going to make a good decision. The best we could do is be unanimous in our recommendation.
I share that thought. I want unanimity as well, if it's possible.
Okay, so let's.
Sure.
Eric? Sure.
Thank you. Thanks, Chair. Staff, did legal weigh into this, the taking or any of the concerns that were brought up by the public? And also, why aren't they here today? It seems like a meeting that they should be at.
Yeah, again, I think that they're scheduled to come for your regularly scheduled meetings. This was scheduled as a special meeting. I do know that they'd like to come to every meeting at which they're available. But they did weigh in terms of both, at the last meeting, they were present and provided concerns over taking. Subsequent to that, we had further discussion with the city attorney and the assistant city attorney, and they felt that the right of the grandfathered allowances run with the land, not with ownership. So they did provide that feedback to planning staff, which was incorporated in the staff report. The second part of your question, I'm forgetting.
Well, I said why weren't they here today, but you cleared that up. It's for they just weren't available.
Yeah.
So is that why was it legal's opinion to put the higher degree of steepness into this, or did
So
they?
from staff, planning staff and legal, we did not provide an upper limit for a variance. In discussions with the legal department, they felt having an upper limit might impose the potential for having a lack of relief, which this ordinance was intended to provide. So that is not a recommendation from staff, but it was brought forth by committee members or commission members at the last meeting. So the option was incorporated, were you to consider a 25% or any percent cap, that was the appropriate location for it in the draft code amendment.
Thank you.
Go ahead.
So this is a question for staff. The 2 or 3 or 4 properties that have been approved in the past through variance that went over 18%. That vehicle for doing that, if the ordinance doesn't change, then the ability to do that doesn't change.
Yeah, those prior approvals, much like the one that's been discussed tonight that's currently under LUBA appeal, were recognized as pre-existing lots not subject to a flag partition. And we had interpreted that the maximum grade for flag partition flag lots being under that section was only applicable to newly created lots. So it was LUBA's ruling that that was not the case because the code didn't stipulate that clearly.
So that's why it came back. This one has finally come back. And then any ones in the future would also come back.
With the stipulation pending the circuit or the Court of Appeals determination on LUBA's ruling.
Thanks.
Thank you, Chair. So if we enacted legislation that essentially looped in these pre-1997 lots and stated that they did have a due process for variance and that those limits or parameters for that were identical to lots post-1997, would that address the LUBA issue?
I think that would be concurrent with LUBA's current
Because they're saying there's
position.
nothing there. Sorry to interrupt you. They're saying basically there's nothing there. It's a gap. It's a gap in the code.
They're saying that the existing code with a cap of 18% applies to all lots.
All lots. That's what they're saying.
All flag lots.
Okay. So we can do nothing?
Yep.
Wow. I make a motion, we do nothing.
Is there a second? It dies for lack of a second. Good try. Well, okay, so one option is to put is to enact wording that says, or recommend wording that says the existing, the pre-1997 lots have the same steepness standards as existing lots.
You don't need to. If we did nothing, you don't need to. It already is. And so it's just in the past when they've been approved, it was.
Well, it's LUBA's interpretation of our code. And so I think it might be better for us to actually put some wording in there.
It's, I don't know.
Well,
I don't know, whatever.
Whatever.
I don't
I
we
think
need to.
LUBA says that's the wording that's in there. I think the decision by LUBA was the existing wording says different than it's been used in the past.
Okay.
And if you do nothing, you have an 18% cap, period.
I'm going to second John's proposal.
To do nothing? Okay, we have a motion on the floor to do nothing.
So just for clarity, that's to make a recommendation to the city council to not pass any ordinance amendment.
To not make any changes. Yeah. Okay. Sure, go ahead.
I do think the point about the pending court case is worthy of consideration. Is there any sense of when that decision might come? Next year? Next week? Nothing? So we could also do nothing today, but as that case, if that case resolves one way or the other before the city council meeting, do we lose our ability to take a position on this?
We can bring it back.
I mean, if we do nothing, we're just doing nothing.
Right, we're just sending.
We're not giving up our ability to,
Make
Make-
recommended changes.
yeah,
to
make
language.
changes to the code.
No.
Unless the city council makes a amendment to the code.
Before us.
Correct. If on October 6th, they take public testimony at a public hearing and make a determination as far as any amendment, then that would.
So that's a practical
Yeah.
limitation.
And as Brandon said at the beginning of the meeting, the council is looking at a bunch of code amendments, one of which deals with flag lots. So I don't think this is the last we're going to hear of flag lots.
And just to add to that, Luba did remand 231 Granite. Once the court decision is rendered, it's likely going to be coming back asking these same questions.
And so they need to file a new application?
They need to request remand under the previous application. Because Luba didn't reverse the decision, Luba remanded it back for the city to address this issue.
Okay. Go ahead.
So in light of that, does it improve the city council's position with respect to Luba if we were to actually pass something explicitly addressing the remand, I guess? Their decision, sorry, the remand's not the right, their decision.
Address the remand until it comes back because it's not a legislative matter.
Okay.
Okay, so we have a motion on the floor. Go ahead, more discussion?
I just feel compelled to say, since I'm the one person who opposed doing this, the last time we left it to the city council to refine recommendations, they changed them significantly from what we had recommended for the manufactured home parks. And I believe not to the favor of citizens.
Go ahead.
Would the commissioners that are set this motion forth consider using up all the clock to get more answers or to have more debate with our legal team before we decide to just do nothing?
It's an option.
I can respond. I mean, I don't need more time. If you need more time, you can request it, but I certainly don't need any more time. I don't see the value in taking more time, personally. I think it's pretty clear.
I see the value in a better assessment of the risk. We've gotten a lot of public response. Including quite a bit today with opinions. We don't know the significance of those 13 lots being, are they really, is there 12 of them that are under, 18% or whatever? I think just assessment of risk is where I come from. So that's it.
I want to echo you there, Eric. When I asked staff if it was certain that the 13 lots identified by geographic analysis would lack access, the answer was no. And that, to me, is like the whole impetus for doing something here. If that's not the case, then that steals a lot of wind out of its sails for me. Maybe another couple of weeks could be valuable. I'd certainly love the opportunity to understand this better. There's a lot of wrinkles and nuance here, and I appreciate, John, that you're certain in your point of view. I see a lot of moving pieces to this, and not least of which is the fact of ongoing litigation. Maybe we can come to a meeting of the minds in the next couple of weeks. So I'd like to move the table of the motion, or how do you do that?
We still have to take a vote.
Okay.
Here.
So the process of identifying whether those lots really don't have access at 18%, like the city GPS, what they have the ability to look at versus a detailed survey is not an appropriate thing to put back on staff, and it's certainly not a thing that we can do. So if you start to look at it that way, then it becomes, again, part of a variance or a way to prove that, and they have to do that anyway. I mean, the minute that you have one of those lots, you have to get it surveyed, you have to be able to prove what you're doing. So I don't think we can add that to what we make our decision on. That's all.
I just want to close by saying we have a limit that is based on historical precedent and some research. It's 18%. There's a limit. So if you can't access the buildable area of a lot without a variance that would allow you to go beyond 18%, then you need a variance, and that variance is not available, so that's lots not buildable. It can be called buildable, but it's not buildable, right? And I think that's the clear message that we need to send, is this not all buildable lots are buildable because they require a variance that's not available. That's land use. And
So
that's the last I'm going to say.
You wouldn't say all buildable lots are not buildable. You'd say all platted lots are
Well,
not necessarily buildable.
Exactly. I mean, I think it's unfortunate the language that's used, but yeah, that's exactly what I'd say. Anyways, I've taken up more than my share of time tonight.
Okay, Susan?
So towards that point, we do have a letter from a landowner that states basically that they understand that their lot became unbuildable in 1997. Do we know that, I'm quoting the letter that's sitting in front of me,
Which,
do we know, that's almost 30 years ago. So on the point of taking, my question is, on the point of taking, did the taking happen in 1997? Or is it still as a risk for us today?
it's still a risk for us today because they haven't come forward with an application.
Can we request a legal perspective on that? I don't believe they've reviewed that, have they? Which kind of goes back to what you were saying, Eric.
Yeah, if you have requests for additional information for legal analysis, we can forward it to the legal department.
But you would need to open the hearing and the record.
In order to consider additional information.
Okay, so we have a motion on the table. Let's go ahead and vote on that unless you would like to withdraw your motion.
Or amend it.
Please restate the motion that's on the table.
The motion is to do nothing,
To recommend to city council that we do nothing.
to recommend to the city council that they not change the existing code, which has served the community for a long time. Yeah.
I'll second that again.
Okay, so we have a motion that is on the floor with a second. So I'm going to call for a vote. After that, we can take another direction depending on the outcome of the vote. Michael, will you call the roll?
Commissioner Herron,
No.
Commissioner McCracken-Jen,
No?
Commissioner Leininger,
No.
Commissioner Kincairn,
Yes.
Commissioner Marr. Chair Werner.
Yes. Okay, so
So
it
it does not
fails.
pass.
No, it fails. Fails for lack of a quorum, lack of a majority. Okay, go ahead.
An alternative motion would be to limit the maximum slope to 19%. That's my motion. I motion that we limit the maximum slope with the variance I'll go to 20%, to 20%
For what lots?
for these flag lots.
These
Yeah,
pre-1997 lots?
yeah, these problematic lots.
Okay,
And up to 50 feet? No, screw the feet.
Yeah.
Just maximum of 20%.
Can I just point out reality?
Yeah.
The lot that you were condemning earlier tonight on Granite Street is 20% maximum.
The motion stands.
is there a second?
So it's not with a variance or just period?
With a variance, you can go from 15% to 20%, but not beyond 20% on any segment of that.
So would you look at F6 as that being 20% because that requires proof by an engineer's stamp that you
Yeah,
have
of course,
to
an
do that?
engineer.
Yeah. So it's F6
So it's
with
actually,
with a 20% cap instead of 25.
You know what?
No,
I withdraw the motion. You figure it out.
Okay, so the point where the cap would be inserted would be under F3 for predating hillside development lots. So this,
right, okay, you're right. So it'd be,
F3.
I withdrew the motion. I don't have an
could you
additional
put the
motion.
motion up on the screen, please?
Chair, I'd like to make a motion if I could.
Sure.
Okay, thank you. I move that the Planning Commission recommend that the City Council approve first reading of Ordinance 3309, titled An Ordinance Relating to the Variances for Flag Drive and Driveway Grades Serving Legal Lots of Record Created Prior to the Adoption of the Hillside Development Standards, amending AMC 15.5.3.060 as amended in the August 25th staff report.
Okay, so you want what's in the staff report to go forward?
That's the motion, and I'm certainly open to amendment.
Okay, is there a second? Well, you can second it and then amend it.
So I'll second it with the amendment that we go to 20%, not 25.
Okay, so the motion is to approve the language that's in the staff report and add in section F3, no greater than 20% for the grade, so that there could be a variance from 15% to 20%.
It also should say not exceed 200 feet in total.
So if you're referring to
Four.
item 4, the cumulative length of all sections of a flag drive exceeding 15%, that was through an interpretation that the Planning Commission and the City Council did, I think, 3 years ago, looking at cumulative length, because there could be
Okay, no, that's
two
great.
sections.
You already had it in there.
Yeah.
I'm sorry. I didn't.
Thank you.
Okay, so
So I'm sorry, I didn't withdraw my motion.
No.
And I didn't hear a second. Was there
Yeah,
a second?
I seconded and amended it to say 20% instead of 25%.
Okay, so this is a motion to amend?
So we need to have a second on the amendment to add the cap on, into the language. Somebody want to add the cap?
Can I second and amend the amendment?
You can second the amendment, second Carrie's amendment, and then add a second amendment?
Yeah,
Sure.
I would like to shorten the 200 feet to 100 feet.
Okay. Is there a second to that amendment? Second to the amendment to lower the footage to 100 feet?
Second that.
Okay. So we have a motion and 2 seconds on the floor. Any discussion? Go ahead.
I would just be careful of prejudice.
I'm sorry, you,
I would just be careful of prejudice, picking out something to isolate one property specifically.
Can I respond to that? I don't think we are. I think we're, the scope of this has been fairly well discussed. I'm moving for this, mindful that the city council is going to have its own deliberation over it. And, and the Oregon Court of Appeals is going to have its say on the Eisenberg matter. The civilization doesn't rise and fall on this. And I think it's better just to move on.
okay, so let's have a roll call vote on the, oh, sure.
What is the rationale for 20%?
I don't know what John's was, but that's what's existing in those lots that have gone beyond, they haven't gone over 20%, any of them. It's still drivable.
Sorry, I couldn't hear you clearly. Is it precedent or is it based on your professional expertise?
Precedent and experience.
Okay, so the First Amendment, we're going to do this in backwards order. The Second Amendment says add the maximum of 20% to F3. Clear? Okay, Michael, will you call a roll?
Commissioner Herron,
No.
Commissioner McCracken-John,
No.
Commissioner Lindinger,
Yes.
Commissioner Kincairn,
Yes.
Commissioner Marr,
No.
Chair Werner.
Yes. Okay, so that dies. Sorry, we should have done the Second Amendment first. The Second Amendment was to change F4 to 100 feet. That was moved and seconded. So, Michael, will you call the roll on that?
Commissioner Herron,
Nope.
Commissioner McCracken-John,
No.
Commissioner Leininger,
Yes.
Commissioner Kincairn,
Yes.
Commissioner Marr,
No.
Chair Werner.
No. Okay, so we're not changing it from 100 to 200, from 200 feet to 100 feet. So now we have the original motion, which is to approve the language that is shown there, shown in front of us, which is to add the changes that are in the staff report as it's written. Okay. Michael, will you call the roll?
Commissioner Herron,
No.
Commissioner McCracken-John,
Yes.
Commissioner Leininger,
Yes.
Commissioner Kincairn,
No.
Commissioner Moore,
No.
Chair Werner.
Yes. Okay, so that died too. So we're back to square one. Should we take a break?
Could I make a quick motion to continue the hearing?
Well, the hearing needs to be reopened if we do that. What would the rationale be?
Unanswered questions about what might get us to yes. In particular, I would like better to understand John's thinking about what a variance does under the existing code and how it answers what staff's attempting to do here. And how it answers the other issues that we've discussed tonight. I would like an opportunity for a meeting of minds.
Okay, a worthy goal?
Second.
Second? Okay, so you're proposing that we reopen the public hearing, reopen the public record, and continue it to a date certain? Okay,
Yes.
that's okay with you? To a date certain, which we can do the date certain of
Be September 8th, I believe.
September 8th, okay. That's our next meeting.
Can we have some discussion about that?
Sure. Excuse me, moved and second, okay. Go ahead.
Thank you, Chair. So if we reopen the public hearing, my understanding is that there could be more commentary. Is that correct? I don't think that's a good idea. I think more letters from lawyers are not going to serve our purpose. More testimony from attorneys is not going to serve our purpose. So I do not think that's a good idea. If there's some, compromise where we can continue to discuss what a recommendation to city council might look like, I think that's fine. But to reopen the whole thing, I think is a very bad idea.
Okay, so we're reopening it because the idea is to continue it. Go ahead.
Yeah, if you retain the record being closed and continue for the purpose of deliberation, you would not have to reopen the record or allow more testimony. And you could deliberate further at the next meeting, but that would also preclude getting additional information into the file.
So we would lose our ability to comment to city council.
If you reconvene on September 8th or September 22nd, your next two regular meeting dates, that meeting could be advertised as a special meeting for deliberations, and you could provide a recommendation to city council because they're not going to consider it until October 6th. But a continuation of deliberation also precludes additional information being entered into the record. If you wanted additional testimony, you'd have to open the record.
And then we have to advertise.
Does input from a city attorney constitute that?
If you're looking for a written testimony from the city attorney to inform your deliberations, I believe that would be additional information in the record.
I'm
they're in a-
personally good with continuing deliberation on the existing record and not asking for additional input from anybody, but rather just continuing our deliberation. The purpose is a mind meld. It's not more input.
Thank you, Chair. That makes sense.
Eric?
So the motion is to open up the public comment and continue. Well, that was the motion.
That
That
was
was
the
what was
motion.
seconded.
So
So
I
I think
withdraw the
I
motion.
think that is what, I think that is what the motion on the table is.
I withdraw the motion. I withdraw the motion, and I
and-
want to replace it with the other thing that we just discussed.
Okay, so do you want to withdraw your second?
No. Here's why. As to your point of more information might be bad, that's my argument for opening it up, because I think some of the lawyers' letters we got definitely make us more aware, and if it's our duty to afford property owners the greatest ability to do what they need to do with their property while protecting the city, that's our duty on both sides. And I just think we got some really good information from a few attorneys. I've asked, can we open it up so that we can ask our attorneys some questions regarding taking and some of the other, and the case that you brought up and where it is in court. And I think that information back from our attorney is what would be vital for me to make a decision. I think more information is better.
Okay, so our motion was withdrawn, but the second was not. So where do we go from here? Do we still have a motion on the floor? I guess we do.
I think you have a motion on the floor.
I believe, yeah.
Thanks, Eric. And even though I said withdraw, I'm going to support it. Thank you. And it's a nice waffle, huh?
Okay, so waffling away. The motion is to reopen the public hearing, reopen the public record, and continue the hearing to September 8th. Any further discussion?
Yeah, I just have one question for Commissioner Herron. Were you here on the 11th? No, you were not.
No.
Okay.
Yeah. And I have a comment for Commissioner Langinger. You brought up a lot of good points tonight, and I really think our attorneys could chew on that. And you're right in law, and I think it's a good thing for them to take a look at and get back to us. So thank you for all the research and time you spent on this.
And so, Brandon, you will take this interest in having the city attorney be at the next meeting?
Yes, but pending the result of this vote on
right.
the motion. Whether-
Right. Okay, Michael, once again, would you call the roll?
Commissioner Herron,
Yes.
Commissioner McCracken Jen,
Yes.
Commissioner Leininger,
Yes.
Commissioner Concairn,
Yes.
Commissioner Moore,
No.
Chair Werner.
Yes. Okay, we have a motion, it got adopted, yay. So we're going to continue the public hearing. I'll reopen the public hearing. I will reopen the public record, and I will continue the public hearing until our next meeting of September 8th,
7 PM here.
7 PM, 2026, in this very room. So we'll be here again. Okay, any further instruction or addition or ideas about what we want to come back before us?
Could we have legal here next time? Or request?
request.
Request, thank you.
And if they don't come, can we have written comment by them?
We can make that request as well.
That's it?
I can't guarantee other division department response.
Can we do anything about the fact that we walked into the room and had 111 pages of material presented to us with no time to review it? No?
No, the people can provide testimony at a hearing, and they can provide it in written or oral testimony. So it can be provided all the way up until 7 PM.
Okay, anybody else have anything for the good of the order under open business, or open discussion? If not, I will entertain a motion to adjourn.
I move to adjourn.
Second.
Second.
All those in favor?
Aye.
Aye. Okay. We are adjourned.